Hey guys, Tammy here. I'm going to give you a little beginner's guide to child custody hearings in this video. I think a lot of people, especially if you're new to the process, don't really understand what's going to happen or what to expect or what the procedure looks like. That in and of itself can be very, very anxiety producing, very nerve wracking. So I think that a little information goes a long way in this arena. Let me just remind you, if you like the content and find it helpful, don't forget to hit like on this video. Also, subscribe to the channel so you get notified as new videos are released. I know a lot of the viewers are not subscribed, so please make sure you're doing that. And also, as always, feel free to share it on social media because a lot of people need this information. When you go in for what we call a motion hearing, okay, this is, it goes by different names. Some places call it order to show cause hearing. California calls it request for order hearing. Some places just call it a motion hearing. Sometimes it's called a temporary orders hearing. Whatever it is, the initial child custody hearing a lot of times is the first appearance we have in front of the court. Everybody's processes and procedures look a little bit different. It's different state to state. The types of hearings are a little different state to state. And even in California and other states too, it can even be a slightly different county to county procedurally, okay? So I'm kind of talking in generalities. I obviously don't know what state, what county you're in your state or any of that. Just take what I'm saying as kind of a generalization. Obviously, you can always consult with an attorney. That's your best path to really understanding. But I think that a lot of the challenge with that is knowing what questions to ask. That's a lot of what I get from my clients is like, I'm going in to meet with an attorney, but I don't even know what questions to ask. When you first file a petition of some kind, whether it's a petition on custody, whether it's a petition for divorce, whatever that petition is, usually you file a petition and the other side files a response, or some places they file a counter petition, okay? Those petition and response don't generally generate any type of order from the court, right? They're kind of a placeholder telling the court that these are the issues. But until somebody actually requests a hearing through a motion, a temporary orders hearing, OSC, RFO, whatever it is in your state, until somebody actually requests that hearing, you're not going to get any orders from the court. So the first thing to know is that in order to get custody orders, if you're having a disagreement about that, you have to actually file the paperwork to ask for the hearing on custody issues. Okay. Now, sometimes when you first file your case, you'll get what they call a conference. Okay. And that's usually just to check in procedurally, kind of get everybody moving in the right direction and all that. Conference doesn't usually involve the court making orders. Okay. Now, sometimes they'll have things called custody conferences, conciliation conferences, family conferences, whatever they call it. Sometimes those will involve the parties potentially trying to negotiate and see if they can resolve the custody issues, right, without the need of a hearing. But assuming that all of that fails and that you're in disagreement, you're going to file paperwork to request an actual hearing. Now, some places, as soon as you file the paperwork, they set the date and give it to you. And then the other person you have to send them the papers. And then the other person has a timeline under which they have to file their response to that request for those custody orders. Some places wait until you file the request, the other side files their response to it, then they set a court date. Okay, so when you get the court date can vary just a little bit in this process. In California, they also send you for kind of what I would say, depending on the county, again, you either go to a mediator, which a lot of states require that the parties attempt custody mediation prior to having a hearing. Here in California, some counties, if we don't agree in mediation, that person writes a recommendation to the court. So it kind of becomes this like mini custody evaluation where this person says, you know what, these two parties don't agree. Here's what I think would be the best plan for this family and for this child. Not all states do that. Some, it's kind of a second step. It just depends. But when you actually go in for the hearing, here's what this is going to look like. First of all, just being in that environment is going to be stressful, right? It's going to put you in fight or flight mode. It is built to be intimidating. Think about it from like a criminal perspective. When they bring a criminal into the courtroom to be tried for whatever crime they committed, they want that to be a authoritative, intimidating environment that you're bringing this person into, because it's how the court commands respect and commands adherence to the decorum and all that kind of stuff in the courtroom. That's how they maintain control, right? Is sort of through that little bit, through that intimidation factor. It's set up kind of with that in mind. And so when you go in and you're in a family law case, although you're not being tried about guilt or innocence, it still does have that intimidation factor and will set off your anxiety and, again, your fight or flight response. So just going down there and observing ahead of time, you can go, it's public hearings, you can go watch your judge, watch the motion hearings. You can call the court and ask what days those hearings happen. Sometimes you can find the schedule online on the court's website and figure out and go watch your judge if at all possible, if you have time to do that. It gives you information just watching the judge, but it also helps your body stop going into this heightened state from being in that environment. The repeated exposure will make it feel more normal to you just by way of the fact of, oh, hey, I've been here before and, it's fine. And then the next thing that's going to happen is typically whoever filed the motion, they will get to speak first. So if you filed the motion, either you or your attorney, if you have one, will speak first, then the other side will get to speak. Sometimes there's a little bit of rebuttal or a little bit of discussion or whatever. And then generally the court will make an order based on whatever information that they have in front of them. Obviously, if the other side filed the motion, it would go in reverse. Their attorney would speak first, or them, then you or your attorney, depending on if you have one or you're self-represented. And then again, the other side will sometimes get a little bit of redirect, cleanup kind of comments, clarification comments. And then sometimes there's a little bit of a discussion if the judge has questions about logistical issues. What time do you get off work? What time do the kids get off school? What time is this? What time? Whatever. If they're trying to craft an order, sometimes they'll have specific questions around those types of logistical things. And then they make their order. The thing is, once they make their order and they don't always say, I'm making my order now. They don't always make it that formally. They'll say something like, okay, here's what we're going to do. That's a common phrase. Or they'll say, okay, here's my ruling. They will say that sometimes. Or they'll say, okay, here's what I've decided, something along those lines. When you hear a phrase like that come out, that means what's coming out of their mouth after that is all orders. Okay. And I always have clients, whether you have an attorney or not, have a notepad and pen with you. And as soon as that phrase comes out of the judge's mouth, as fast as you can, write down as much as you can get of what they say, because capturing those orders is important. The judge's clerk will capture them also, usually in the minutes and things, but they're not without error. They're human beings. And so when you're writing things down, if you then come back and go, oh, wait, what's in this minute order isn't the same as what I had written on the paper, there's something missing. Maybe your attorney goes back and orders the transcript. I mean, that's expensive. But if it's a significant enough issue and there's an error and we're aware there's an error, being aware of it is the first problem, then you can order that transcript, do a cross comparison and be like, okay, that wasn't the judge's order. Here's what the order actually said. It's helpful to write that down and know. And a lot of times the client gets home and then we're waiting a few days before the paperwork's processed. We don't have copies of anything written because we're waiting, all that's pending. And in the interim, you don't remember what the orders were that you're supposed to follow. So write it down. Take responsibility for that yourself. I'm sure your attorney will be writing feverishly also as that's happening. But again, none of us are perfect. Our brains don't always catch everything. So as much as you can write down of it, you'll just be one more checkpoint that can be crossed off in this process. Most of the time, these types of hearings are short. They last 20 to 40 minutes. They don't typically take testimony, put you on the witness stand, in other words, at these types of hearings. They can, it's just not typical. Typically, these arguments are made through the written narrative or declaration or affidavit that we file with our request for the orders. And so there's not usually a lot of live testimony at these types of things. But once the judge makes their orders, it's over and done. And whether you agree with it or whether you don't, it's done and that's the order. It's already left the court's mouth. So you standing there and arguing at that point is not helpful. It can also kind of cause your judge to remember you in a negative way. And the next time you come back, they remember that you did that or you had that reaction and they're not happy with you. I would also say a lot of times clients come out and they don't feel the greatest about the result. I find a lot of times the result's a lot better than the client thinks it is when they start to really unpack it and understand what all is involved in the orders that they were given. You're in such a heightened emotional state and you're under so much stress from just being there at the hearing that honestly, I wouldn't try to evaluate anything for at least 72 hours. They say it takes about 72 hours for your body to decompress from that heightened level of stress. Okay, so don't try to evaluate too much about what happened until you're past that point where you can think about it more in a logical way and less in an emotional way. But these hearings move very, very quickly. You go in, it's boom, 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 boom. All this stuff's being said back and forth. Half the time, if you're, a lay person that doesn't work in any of this, as I was when I went through my divorce and custody situation, you don't even know what's happening. You don't even understand what they're talking about. You don't even know what any of it means a lot of times, especially when it's procedural stuff, right? If it's stuff relating to your case or incidents that have happened, then obviously you're going to be aware of that. But a lot of times kind of the procedural discussions and things will just sort of go right over our head. And then we come out and we're frustrated and we don't like the orders, but yet we didn't understand a large portion of what was said. So how can you even evaluate whether that was a good outcome or a bad outcome under the circumstances? Okay. If you're not happy with it, I will tell you that one of the worst things you can do is to come out and berate your attorney in that moment. Because again, you're emotional. What that does a lot of times is, again, your attorney's a human being too. And it might make them kind of like not too anxious to come back and advocate for you the next time, right? I mean, I don't think anybody does that consciously, but I think that, when we have negative experiences with somebody, it can sort of put that subconsciously into us where we're just not kind of as on board as we were before. So again, wait. Patience is the key to all of this. And you want to just wait. Let's give it a couple days. Let's evaluate the outcome at that point. And then sit down and have a non-emotional conversation with your attorney about, hey, can you help me understand why the court made these orders? Can you help me understand why you did or didn't make this argument or that argument? Can you help me understand what information would be helpful for you for us to be able to change this part of this order moving forward? Ask constructive questions as opposed to coming out of the courtroom, venting all your emotions and your frustrations to them, and then going home and then coming back and doing another hearing 2 months down the road and going through the same process. That's what most people do. Most people don't give it the appropriate amount of time and they don't sit down and have a constructive debrief with their attorney, mostly to help them understand. You as the client need to understand what's happening and what you can do to help your attorney advocate for you in this process, or advocating for yourself, breaking that down and trying to figure out, if you're self-representing, how can I advocate for myself in a better way? So if you'd like help deciphering all this, figuring out what's happening, whether it's, in the courtroom, out of the courtroom, good orders, bad orders, whatever you got going on, I'm happy to brainstorm and talk through that with you. If you go to divorceuniversityonline.com/VIP-coaching, there's information on that page about my group coaching programs for moms and for dads, and also information on my exclusive one-on-one VIP coaching programs. You can take a look at that, see what might be a good fit for you. And I will see you guys next time.
We'll grow in number, fueled by them to see the horizon, turn us to thousands.